Good day, everybody. I'm Sam Shihab with the law firm of Shihab, Burke, and with me,
Brian Burke from Shihab, Burke.
Today we're going to talk about a new presidential proclamation that was released on the 19th, restriction on entry of certain non-immigrant workers. It's a bombshell that dropped without any warning, restricting H-1B workers to enter the United States subject to a $100,000 fee. With exemption of national interest that was attached to it.
Yeah.
And that's effective, by the way, Sunday, which was yesterday.
Yeah.
Today, just for a reference, should you watch this YouTube in the future, today is September 22nd, 2025, the day after the implementation of the presidential proclamation. And since the 19th, Brian, until into the weekend, all kind of clarification.
Yeah. Since the original proclamation, we have one, an FAQ from the White House, two, an FAQ from USCIS, three, a policy guidance from Customs and Border Protection, and somewhere in the stack still there's another policy guidance from USCIS, and there's probably more coming out literally as we have this conversation.
And more coming out, and few verbal releases from various cabinet members.
Sure.
And also Twitter releases as well.
Yeah.
We wanted to stick to the written text because any verbal clarifications are not well thought of, and I think are made in a rush. But sticking to the documentation, we want to talk about what is this proclamation, what it means. We're going to talk about what is clear, what's not clear, where to go from here going forward, and what's the political undercurrent that's going on here that may impact the direction of this proclamation. So to begin with, let's start with the proclamation, Brian.
Yeah.
Do you want to read off the relevant language?
Well, I'm going to maybe just cover the preamble in 15 seconds.
Okay.
Right? And basically the basis for this is they say H-1B workers are basically depressing wages, taking the place of U.S. workers. They don't like that. So in response, here's this proclamation. And the proclamation says, entry to the United States is restricted for H-1B workers, except those aliens whose petitions are accompanied by or supplemented by a payment of $100,000, subject to certain exceptions set forth below. And this is for a period of 12 months going through September 21st,
2025.
Yeah.
With the ability to extend.
Yeah.
Sometime in April of 2026, recommendation of extending it will be given to the White House to further extend this.
But continuing through September 21st, 2026
yes.
for now. Yeah.
Okay. So bottom line, it begins with a very broad language.
Yes.
That says every H-1B filed after September 21st. Midnight, which is Monday, because business day begins Monday, is going to be subject to a $100,000 fee.
Yep.
Then they back off.
Yes.
They begin taking few steps backward and saying, not so fast, my friend. We need to slow down and clarify this. And USCIS, after few cabinet statements issued and press releases, a memo is released.
Yeah.
And in that memo, it takes a major step back in an attempt to clarify that, and that's USCIS memo dated September 20th, 2025. And what does this one say?
Well, I happen to be holding the Customs and Border Protection one, but it says pretty much the same thing. It says, and they both read identically. I'm just going to hold them up. This proclamation only applies prospectively to petitions that have not yet been filed. So, okay. So gives us a lot of information to work with. Basically, we have read the executive order that says no admission unless we've gotten $100,000, but it doesn't apply to petitions that have been already filed. It specifically says it does not apply to aliens who are the beneficiaries of petitions that were filed prior to the effective date of the proclamation, or are the beneficiaries of currently approved petitions, or are in the possession of validly issued H-1B non-immigrant visas. So
that last one, does it mean stamp? Is it a visa stamp?
It seems to mean a visa stamp to me by the general immigration attorney's way the word would be used. Yes.
So this provide a clarification and probably a relief for a lot of people because it clarified half of the law.
Yeah, like people say, I literally had an email on Saturday saying, we're about to file my H-1B extension on Monday. Is this going to, interrupt that essentially?
Exactly. Yeah. So we're going to go through 3 or 4 scenarios for you that are kind of what everybody's asking.
Yeah.
And trying to clarify that. Then we're going to take questions. Now, remember, we have our website, immigrationquestions.us. Now, you are free to drop your questions live on YouTube, and we'll try to answer all of them if we can today. But if you also want to ask questions that you don't want your questions attached to your handle, social media handle, for your own privacy, obviously now our social media is being vetted clearly. You can go to immigrationquestions.us. That's our website. We own that website. You can submit your questions, and we will get into those now. I know there's some questions that came through the day, and trying to answer as many of them as possible.
Yeah.
But here's the first scenario, Brian, which is the first clear. We're going to begin with the clear stuff, right?
Yeah.
What is clear here? Give us a scenario that's 100% clear about this H-1B fee that is very clear to us.
Yeah. An H-1B employee seeking to change employers in the United States after 9/21. And the bottom line is doesn't apply.
Yes.
Pretty clear.
So an H-1B change of status an H-1B change of extension. Let's start with H-1B extension.
Yeah.
How does that look?
This policy, the $100,000 fee should not apply.
Okay,
For our
excellent.
reading.
Excellent. What about an H-1B amendment?
$100,000 fee should not apply. If you're here in the United States right now, $100,000 applying to people who are inside the United States right now, $100,000 fee should not apply.
All right. And I may be jumping the line here, but I'm just going to go by the normal stuff. How about a change of status from an H-4 to an H-1B for somebody that had an H-1B before, and now it's not a cap case, it's a cap exempt, and they file it after September 21st.
So one thing I'm not sure we brought it up earlier is this applies to people who are outside the United States. If you were inside the United States right now, change of status from any status to H-1B, this $100,000 fee should not apply to you.
F1 to an H-1B, if you had a prior H-1B as an F1, no problem.
Shouldn't apply to you.
H-4 to an H-1B, not a problem.
Yeah.
TN to an H-1B, if you had a prior H-1B, not a problem, as long as you're in the United States and you're applying in the United States. Okay, excellent. What's the second example?
Let's see here. An H-1B cap subject worker who is currently in the U.S. on F1 status and intends to remain for the foreseeable future. So this is somebody who is maybe going to be filing H-1B cap, who's here on F1 status, might be filing H-1B cap in the fiscal year 2027 H-1B cap. Planning to change from F to H. I think we've covered that pretty well. This should not apply to you as this policy is written, as we understand it today, 9/22.
So H-1B.
Yep.
Future H-1B, cap subject.
Yep.
For next year, the person is in the U.S. And applied in the lottery, selected in the lottery for the fiscal year 2027, which will be filed in 2026. And selected and filed for an F1 change of status. This policy does not apply to them.
It would appear so, yes.
It would appear so. Okay, excellent. Next example.
Yes. Let me see here. An H-1B cap subject worker who's currently abroad and it's going to be going through the fiscal year 2027, as in the coming year's H-1B lottery, but have never been on H-1B status before, never traveled to the U.S. before. That person, they are going to be subject to this fee per this policy as we read it today.
A $100,000 fee must be paid to allow this foreign national
to be admitted to the country,
unless they are subject to the waiver. So there's a waiver process, and the waiver. This is probably a good time to talk about the waiver. The waiver that is suggested in the presidential proclamation is one that can be by person, individual waiver. It could be a profession waiver. We just heard that I think Bloomberg just released a news that physicians may be the first to receive the waiver very soon. It can apply for an industry. It can apply for a company. It can apply for, hey...
an alien, a company, or aliens working in industry, if the Secretary of Homeland Security determines the hiring of such aliens to be employed in H-1B special preoccupation is in the national interest.
Yes. So they can say AI, they can say Amazon, they can say doctors. They can say any of that. But if that person is not subject to the waiver, you can try the individual waiver. But if the waiver doesn't go through, that person is clear that is subject to the $100,000. Okay. What's the next one, Brian?
Let's see here. A fun variation of that is the people who were filed H-1B cap cases outside the United States in fiscal year 2026, as in the H-1B cases we would have filed in, from April 30th to June 30th this year. Those people are not going to be subject to this proclamation because per the policy from CBP and USCIS, this proclamation only applies prospectively to petitions that have not yet been filed. Meaning if your H-1B case has been filed, it is pretty clear that it does not apply to you.
Okay. So again, it does not apply and it's clear. Right? Okay, excellent. Now we enter the gray area? We enter the gray. What's the first gray, Brian?
So how about if you're outside the country right now, you have previously obtained an H-1B approval and an H-1B visa, but they're no longer valid. And your employer now wants to bring you to the United States because you have H-1B time left, or approved I-140, meaning you have infinite H-1B time. Can you file will your case be subject to this $100,000 fee? And boy, that's not clear because the messaging on this is sort of not clear in terms of immigration attorneys' terms on this.
So they use the language new petition. Okay, they use the language, it does not apply to it only applies to new petitions. But the new petition in our language is not something, we have a new employment, and we have a cap subject petition, but we don't have a language in our term of art as lawyers, new petitions. So this language is not clear, and it can be one of two interpretations.
I mean, just pulling from the White House FAQ that I have here, it says, this proclamation does not change any payments or fees required to be submitted in connection with any H-1B renewals. So in that scenario, I could make a great immigration attorney's argument to say, this is a renewal. This person's had H-1B in the past. They're renewing their H-1B. They have time left on their H-1B. They're not subject to this filing fee. But it's not clear as to whether or not, when that case gets to USCIS, whether they're going to agree.
Well, it's a renewal of what? That's the problem. What it leaves is a renewal of the person's unused H-1B, or is it renewal of the person's employment?
And it goes back to that question. What you're saying is, what is a new H-1B petition?
And that's where you start to get gray area. However, I think we tried to split the gray to two groups. Likely yes and likely no. So this one, and again, this is our best guess because it's a gray area and it's not explained.
And the situation is developing. Again, today is 9/22. Our answers on this might change literally in the 20 minutes after we're done with this presentation.
If they come out with something new. So this is, we say, likely does not apply, meaning that we are thinking that the new petitions, meaning cap subject?
Well, in my notes, we have walked that back a little bit because we're not,
We're not sure. This is right there in the center of the gray. We don't know.
Before presentations like this, we always talk about what our thoughts are, and the answer is everybody in the office was talking about what does this mean.
So we don't know.
One that I think is a little bit more favorable is if you file for a change of employer in the United States while in the United States and it gets approved, then you travel and apply for a stamp. It appears that you should not be subject to this. If you file a change of employer right now, you're inside the United States, you should not be subject to the fee, meaning you won't be subject to this when you travel. You should not be subject to this when you travel.
The argument in favor of that position that we've taken, that this is a gray area, but it is favorable gray area, and by no means are we recommending anybody to travel outside the United States right now.
We're taking your questions, and that's going to be a common one for sure.
Yes, because we really don't know what's going to unfold in the next couple months, probably in the next couple months. Now, we're going to talk about that because trade talks with India has resumed full speed with a deal to be signed by November. I think news released 5 minutes ago. And do you think trade talks has anything to do with this, Brian?
Sam, get your trade talks out of my pure, sweet immigration law. Those things have nothing to do with one another, sir.
Exactly.
Nothing to do with one another.
Exactly.
Yeah.
So the change of employment in the United States, you file an application post-21, so post-September 21, meaning that after the proclamation is effective, and you file for a change of employment, extension of stay, H-1B amendment, and you get a new H-1B, then you travel outside the United States, and then you need a visa to re-enter.
Yep.
It's a gray area, but we believe that you're not subject, you should not be subject to the $100,000, because if they require $100,000 for this scenario, they just have imprisoned 800,000 people in the U.S.
Yeah, but the reason why it's gray, I want to come back to it, is because it is not clear what they mean by a new H-1B petition. They said, the policy from CBP and USCIS, this only applies to prospective petitions that have not yet been filed. And that petition that's being filed today has not yet been filed. Yeah. And even though this is only supposed to apply to people who are outside the United States, suddenly, if you're outside the United States, after your petition is approved, I could see them saying, "Wait, where's the fee?" But you're outside I wasn't subject to it. I was inside the United States, but you're outside the United States right now.
Yeah. So inside the United States, H-1B amendment extensions, I think you're in the clear.
Yeah.
Outside the United States, fiscal year 2027, H-1B subject. We have had a quick conversation about cap exempt applications from universities. Yeah. If the person is outside the United States, it's going to be also subject to the $100,000.
Yeah.
Singaporean H-1Bs, potentially.
Yeah.
We don't want to dig into that very deeply.
Yeah.
Then the question here, before we open this to Q&A, is, I think, a couple questions. Does the United States President have the legal authority to implement a travel ban?
Yes.
Yes.
Case in point, the Iran unfriendly countries.
What is referred to as the Muslim ban?
I didn't want to say it, but yes, whatever it's called right now.
Everybody calls it, yeah. And then which obviously the U.S. Supreme Court clarified that a ban based on national security, yes, but based on religion, no. Yeah. The second question, can the president impose a fee at the consulate for admission to the United States?
Yes, they can. Yes. People already pay fees at the consulate.
Yeah. Without going through the public notice procedure, which I believe, yes, they can bypass that. That's the authority of the president.
Now, curiously, you did your research on that, but if you read the memo or rather the proclamation, it says this is a fee you must hand over to USCIS in the context of your H-1B petition filing.
That's number 3.
Yeah.
You're getting ahead.
Okay. All right.
Can the president require that to be a filing fee, admission
fee included as a filing fee, essentially, with your USCIS I-129 petition?
And that's a big question.
Yeah. It sure seems like a filing fee if you're submitting it to USCIS, the people who definitely don't handle admissions.
Because a lot of people may change their mind and may not want to be admitted.
Yeah.
They can say, hey, I got an H-1B approval. Okay, well, I don't want to come into the United States. Yeah. And you paid the $100,000.
They're not giving that back to you?
So that is a big question. Yeah. And then the next one is and Attorney Joe Morhart thinks we can the President of the United States condition the removal of the travel ban on the payment of non-refundable $100,000? And that's a debatable, I guess, but that's a question.
But I mean, it says, the fundamental conversation we were having before we came in here is, okay, the premise of this executive order is letting these people in is against the national interest. Boo. How is their entry in the national interest by handing over $100,000? And I think the conversation we're having is, well, depends upon where that $100,000 goes.
And also, what is the national interest?
Yeah.
Or not the national interest? What is the national interest that they're trying to protect?
Yeah.
Right.
Yeah.
Okay. So I hope we've given you guys some clarity. I know we've given you a clarity on what's clear, and we've given you clarity on what's not clear.
Yeah.
And I can promise you that things will change in the foreseeable future about this. This is not the end of it.
Fun fact, I suspect we're going to be talking about this on Wednesday at our Wednesday session at 6 o'clock as well, because what else would there be to talk about, frankly?
Yes.
Yeah.
So there's going to be a lot more. There's definitely political pressure on this 100,000. And the problem is the 100,000 is just
a number.
Where does that number come from? Why not 50? Why not 250,000?
It's an oddly round number. Why not 999,999? It'd be fun, you know?
Yeah, so that creates also a challenge for this proclamation. Be that as it may, we have it. I don't think, one thing I can say comfortably, unfortunately maybe, or fortunately, I don't know how you look at it, the H-1B program will never be back the way it was before this proclamation. Whatever resolution of this proclamation is going to lead us to a different type of an H-1B.
We should talk resolutions. Sam, do you think there's likely to be some lawsuits on this thing?
Yeah, but I think at the end of the day, when the dust settles, lawsuit or no lawsuit, business is getting involved, the conversation is going to come out with probably a new face for this program.
Yeah.
At the end of the day.
Well,
and maybe a better face.
Here's what I say to that. I'd say the new face of this program has to be something that's done through the law. You know, Congress, the H-1B rules are written by Congress and then signed into law by the president, or laws rather, excuse me. And that's not something that's changed here. Well,
unfortunately, I mean, part of the problem is Congress hasn't made any changes that are meaningful. I mean, this program is what, 1995 or 1990 program?
I think it's 1990, yeah.
Yeah, and this is
last changes were around the year 2000.
A long time ago.
Yeah.
A long time ago, and that's sad, right? We need things that are more in line with what we need.
I want new visa categories, darn it. I'm sick and tired of the same, 5 or 6 employment visas. I want a new category of employment visa to solve all the other employment problems we have in the United States.
Exactly.
Yeah.
So let's go into immigrationquestions.us, log into that, and then put the first question here on the screen, Brian.
Yeah, I'll let you get to the first one we have here live, and I'll go.
Yeah, I get that. So I have a stamp visa until July 26. I have to travel to India next week for 10 days. Can I travel? Well, the question is not can you travel, the question is can you come back after you travel? And I think that's the question you're asking, just to clarify. And our official position on this is we do not recommend that you travel. Now, we can discuss the law and the current interpretation, but there is no guarantee that if you travel on day 9 of your return, the interpretation changes, which will exclude you from being able to come back to the U.S. So clearly, do not travel. But I'm going to answer your question based on today, September 22, 2025, based on what we know today. You have an approved H-1B. And I'm assuming you have it approved prior to September 21st, and you have a valid stamp. According to USCIS, you should have no problem traveling and re-entering the United States per the memorandum that they've released. They said here, this proclamation only applies prospectively to petitions that have not yet been filed. So that's bolded. So your petition has already been filed and approved. And then it talks about...
Does not apply to... those who are in possession of a validly issued H-1B non-immigrant visa, which we think means classically a non-immigrant visa stamp in your passport.
Yes. So that's the answer to your question. Now, again, I repeat, Dilip, that's not something that I would say I'm going to recommend for you to travel right now because good luck trying to convince...
This whole thing itself is evidence of the fact that things can change on a moment's notice, essentially.
I'm going to take the second one here, and then we'll go to trying to be even on immigration questions and online here so we can be responsive to both groups. My H-1B extension with the same employer is approved. I have a visa interview in October 2025. Can I go for interview? Again, that's the same question.
Slightly different question. This person doesn't have the visa yet. But the bottom.
Well, he had the prior. Yeah.
He has an approved petition prior to this date.
So the
proclamation doesn't apply.
Absolutely. The proclamation does not apply. Again, we do not recommend that he travels. I cannot recommend for you to travel.
This is developing so much, and that's that. So I'm gonna go backwards through our immigration questions.us, considering that some of them came in before this proclamation came in. So here we are.
How about if we focus on the proclamation, Brian?
Yeah, that's what I'm from the September 22nd. So that will be a proclamation.
And then anybody else, we will address your questions either by emailing you if you dropped your email or by bringing it on Wednesday.
So I'm going to try to give this a little copy and paste in here so everybody can see it. I think we should be able to get the text of it in there. Nope. Copy, paste. There it is. Here it is. I moved from H-4 to H-1B in 2023, but I don't have stamping done on H-1B, though we have the extension done along with the LCA amendment this year. I'm exempted from this 100K fee or not, as I don't have stamping done, not evidence,
Not even once
on H-1B. So again, I'm going to go by the USCIS policy memorandum.
Begin by saying we do not recommend that you travel.
Agreed. We do not recommend that you travel. Yes.
But we will answer the question.
The proclamation does not apply to aliens who are the beneficiaries of petitions that were filed prior to the effective date of this proclamation.
Your petition was filed before the effective date of this proclamation, and therefore the clear interpretation of this memorandum today is that it's not applicable to you and you're not subject to the $100,000 fee.
Yeah.
All right.
Yeah.
Next one.
Yeah. I'm going to do an immigrationquestions.us question.
And then we'll move on to life and trying to kind of split it that way.
Yeah. Add, and we're going to go bam.
So this one, it says, I am a student with an F1 visa, country in the United States.
Here it is. Get it up there.
Will apply for an H-1B in the future, May 2026. Does the $100,000 fee affects me? So this is the example we had on point. And Brian?
This 100K fee applies to those applying for entry to the United States. If you are here in the United States, first of all, our recommendation is do not leave the country. And it does not appear as of today, 9/22/2025, this proclamation will apply to you because you are physically present in the United States right now.
So if he wants to go and visit, kind of spin off this one, Brian.
Yeah.
Let's assume he's a student. He has not applied, obviously, in the lottery or applied in spending. But can he leave on an F1 and come back on an F1 if he has a valid stamp? Is there any concern you have?
Leaving on an F1, coming back on an F1? They touch wood, no problems.
No documented problems, and this has nothing to do with H-1Bs.
Yeah.
So there's no issue. So in a situation like yours, while clearly it doesn't apply to you even after you get your H-1B because you are here in the United States. So if you have, but I think we threw that in the gray area in terms of leaving. So you're on an F1, you're on an F1, you apply in the lottery, you're selected in the lottery, now you apply for a change of status to H1. Now you're on an H-1B visa, you don't have a visa stamp, then you want to travel. Let's say
suddenly you're applying for entry
in 2027, assuming the law doesn't change and we're speaking under today's rule, and then you're coming to the embassy and applying for entry, and the petition was filed post September 21st, and therefore we think this is a gray area because on one hand the petition was approved here as a change of status, so it's not an entry, and you obtained that while you're in the U.S., but it was filed after September 21st. And you're applying for an entry, so a strong argument can be made that you're subject to the $100,000. That's if you travel after you get your H-1B.
Yeah.
Now, if you travel before you get your H-1B on F1 and come back on F1, you're not subject to any restrictions per this rule today.
Yeah. Go back to some of the live ones here?
Yeah.
Sure. Let me see here. I think this is it advisable to travel to India this December if I have to go and then get visa stamping? The stamping is for a change of employer, and my current stamping with previous employer expires December 31st.
So assumption number one is that this person has a valid H-1B that was filed and approved prior to September 21st.
Yep.
Okay. And again, while we do not recommend travel, and things can change in December, so you should probably look at the attorney's recommendation in December.
I always tell people to talk to me before travel because, especially in times like this,
Again, USCIS memo, September 20th, about the proclamation. It says, this proclamation only apply prospectively to petitions that have not yet been filed. So your petition has been filed, and therefore, the strict interpretation of what we have today is it does not apply to you.
Yeah. Yeah. From Trendicon.
My kid's I-94 got expired on 14th of April 2020, and renewal was filed on April 13th, 2020, but the approval came from July 9th, 2020, so there's a gap. I'm planning to file an I-45 next month. Will that be a problem? Digression, but let's answer that question. So, Brian, what do you think?
By bottom line, the record's going to show there's a timely filed H-4 extension, unless there was some sort of maybe error in the way it was requested, the extension. The bottom line is, I don't consider it likely to be a problem for somebody.
Well, when I say filed April 13th, I don't know whether it's mailed April 13th. I'm interested in see when
the actual receipt date I see.
When it was received.
Yeah.
And if it's received after the 14th, so April,
But
May,
they
June,
approved the
July.
case, though.
Well, you got 90 days of potential gap.
Yeah.
So is that INA 245K?
Yeah, I believe that.
180 days
Yeah,
apply to dependents.
yeah, applies to dependents, yeah.
So you also have a second avenue, which is INA 245K, that's applicable to dependents up to 180 days of status violation.
Yeah.
So I see more than one avenue for you. If it's received timely, clearly you have a defense that they made an error. And if it's not received timely, but there's a 90-day gap, INA 245K can save the day for you. So you're fine.
I don't see it very likely that scenario comes up at all. You have to find one board officer going after a kid's H-4 status from 5 years ago. It's the bottom line, especially in a scenario where it seems reasonably clear that they were compliant by filing timely.
And given the fact that he is under 14, under 18, well, he could be under 21, so we could be subject to the unlawful presence. But he should be fine.
Yeah. Here's, I'm going to go back to immigrationquestions.us, so we're going to switch to those right quick. Here's a relatively easy one. My keyboard doesn't seem to be working. That's fine. Apparently, well, the question is here, will the 100K fees apply to H-1B transfer on or after switching companies? And the answer is, and get that chat off here, no.
Repeat that again.
So will the 100K fees apply to H-1B transfer on switching companies? And the answer is, if you're inside the United States, no.
It does not apply, and we categorize that in the clear area of the policy right now. It clearly does not apply. The question becomes is whether or not you can travel and get stamping after that. That's in the area that's unclear at the present time.
One thing I just want to come back around and emphasize again, this is a fee related to your entry, admission to the United States. And if you are here in the United States and you are staying, it's going to be hard for me, as we understand the policy right now, to find a problem for you that makes you subject to this fee.
Yeah. It's very interesting that it is assessed at the and we've talked about that, assessed at the filing stage, which I think that's one of the weaknesses. But they can tweak that. That's easily fixable from their standpoint.
When I think about it, I mean, there's the concept of consular non-reviewability. It's big discretion for what the activities are at the consulates abroad, government activities overseas, limited ability to challenge it. And I think that's one of the reasons why they sort of do it that way. But again, it seems peculiar, especially asking USCIS to collect a fee for admission, which is not something that everybody's going to do, essentially.
Yeah. All right, next question here.
And go back to the one more of these immigrationquestions.us fees. Let me see. Captions, add, paste. Okay, I'm at the limit here, but my I-140 is approved. If I take a career break and come back again after 3 years, 5 years, will the same rule still applies? Is this rule applies to extensions or changes in employment? If anybody outside the U.S. got selected in 2025 H-1B, do they need to pay the fee? So maybe I can break these into 3 different questions here. How about that?
Yeah. So the first one here is maybe you should not copy that, and let's go into the question, Brian.
Yeah.
Slowing things down here. So I-140 approved. And he wants to take a break and then come back a few years from now. Would that be applicable? Would the H-1B be applicable to him? The answer is 3. I'm going to give you the answer today based on today's rule, but I can guarantee you that in 3 years, the rules will be completely different than today. So keep that in mind. But today, I think that goes in the
gray area.
In the gray area.
Yeah.
It is not clear based on what they have released so far. That we do not know.
So question 2 for this individual is this rule applying for extensions / change of employment? And the answer is no, not unless, if you're inside the United States applying, the answer is no, the fee doesn't apply, because again, this is an entry related fee. And finally, if anybody got outside the USA selected in the 2025 H-1B, being, I presume, referring to the fiscal year 2026, the ones we just filed them up until June 30th, do they need to pay this fee? And the answer is no, Per the proclamation, it applies only to petitions that have not yet been filed. There you go.
So let's do a spin on that one.
Sure.
So somebody applies for an H-1B visa, Brian, in 2015.
Sure.
And that person gets a 6-year H-1B, spends 2 years in the U.S.
Yep.
and leaves the U.S.
Yep.
We know we have a recapture rule that we can recapture the remaining years.
Yep.
Now you file for an H-1B,
Yep.
okay, for new employer.
Coming back to the United States to recapture that time, yeah.
Yes. Apply in the gray area, right?
Gray area. Well, they say this policy memorandum says it applies to petitions that have not yet been filed. So that one has not been filed, right? But it also says it doesn't apply to beneficiaries of petitions that were filed prior to the effective date of this proclamation. That person has an H-1B filed prior to the effective date of this proclamation. And that's that. And also the White House policy that we have here somewhere in my stack. There's so many. Here it is. Well, I can't seem to find it at the moment.
FAQ?
Here it is.
Here's the FAQ.
It does not change any payments or fees required to be submitted in connection with H-1B renewals. I could arguably say that's an H-1B renewal of some sort.
It's a gray area.
It's a gray area for sure.
Yeah. So more gray. I mean, what we know is clearly, if you're outside the United States, fiscal year 2027, cap exempt cases, never had an H-1B before, applying with no stamp.
Yeah.
That is applicable.
Because we've all been shouting back and forth with this office all day, and there's a sort of a broad reading of it that says this is designed to impact next year's H-1B cap only, essentially. And there's the more conservative version that says this is designed to hit any H-1B that's filed after today for anybody attempting to actually get a visa into the United States, and that's where all the gray areas really are.
Yeah. So, and again, I repeat, there is a trade talk with India.
Going on.
And I'm sorry, but
what was it? The trade minister from India was literally took a red eye to the United States. Already here.
Well, a high official.
Yeah.
I'm not sure.
I don't know who. What? Yeah.
Yeah, but took a flight immediately to the U.S. upon the release of this proclamation. I think probably was airborne within hours.
Yeah.
Of this proclamation.
Yeah.
That basically want to start discussions and resolve issues.
Yeah.
So hopefully, I mean, clearly. It is, it's just a sudden surfacing of this rounded $100,000 number in a proclamation has to do with politics.
Yeah.
I'm not sure which politics, which is Silicon Valley politics, whether India trade talks politics, both.
Yeah.
We don't know.
I mean,
but given the fact that it's incredibly politically connected, I think it will change very quickly in time.
Yeah, I mean, literally, this thing could be a non-issue a week from today. It's a proclamation. It could be.
I'm not sure if it's going to be a non-issue. You're a lot more optimistic than I am.
I am optimistic,
but it's going to
yes.
change.
Yeah.
We're going to say it's going to change.
Yeah.
All right. Sounds good. Any more questions, Brian?
Oh, plenty of the live ones here.
Okay, let's jump in the live ones.
Yeah, let me see here. Let's see here. Here it is. Raghavendra. I know. Yeah.
I have a valid H-1B stamping and planning for international travel this week from the U.S. Will there be any issue at the port of entry while returning back? So I have a valid H-1B.
Yep.
I'm assuming I have an H-1B that's been approved prior to September 21st. Yep. The clear reading of the policy, the $100,000 does not apply to you. However, we do not recommend travel because it's a moving target.
It's a time of absolute chaos, that is for sure.
Let's take the next one, Brian.
Yeah, get right to it. Here we are.
My H-1B visa stamping has expired, but my H-1B approval is valid until 2028. If I travel to India for stamping, what will happen? Again, we don't recommend traveling, but your case was filed prior to September 21st, and the proclamation interpretation by USCIS, it does not apply to you.
Yeah. From Tech Topics.
I am on compelling circumstances EAD with H-1B in past. Will this fee apply to me if I re-enter later on H-1B? Your H-1B will be filed after the effective date of the proclamation, but it is unclear whether this will be viewed as a new petition or an extension of your prior H-1B, and that's why we have a problem with the language being used, and therefore the answer to your case is we are in a gray area with you as to whether or not it applies to you.
Yeah.
Next one.
My extension was approved in 2024 and approval is valid until 9/2027, but visa is not stamped yet. Can I travel to India for visa stamping in coming year in 2026 or 2027? Thanks. Again, reiterating, don't recommend travel because it is a developing situation. This weekend shows how quickly things can change. The answer is you have a valid H-1B approval. Proclamation applies only to petitions that have not yet been filed as of the 21st, meaning it appears if your petition was approved in 2024, it means the proclamation should not apply to you.
And you're not subject to the $100,000.
Exactly.
Okay.
Yeah.
Next one.
Here we are.
Hello team, recently received EB green card. Can we travel to India 35 days as per current situation? Absolutely you can. You are a lucky dude. But thanks for logging into our channel and listening to us. But yes, absolutely you can.
Bottom line, this proclamation only applies to individuals on seeking entry on an H-1B visa, and there's what documents needed to carry, current employment letters needed. Bottom line, as a permanent resident, you are entitled to enter the United States. You don't even have to have a job, is the bottom line.
Yeah, as long as you have your departure is temporary for less than 6 months, nobody's going to ask you any questions.
Here we are.
One of two. My husband got selected in the H-1B lottery. Both of our files received date is June 18th. We switched his application to premium processing September 14. We're changing our status from F1 to, do you think the H4, okay, so let's go back to the first one.
Sure.
I think there's the question. So does the proclamation apply to this person, Brian?
No, because they're physically present in the United States and their H-1B has been filed before the effective date of the 21st.
Okay, excellent. So they have 2 of 2. Do you think my H-4 would be approved at the same time as his application? Normally they do. Can I drop off my school when his application is approved? No, you cannot until you get the approval. Yeah. Or should I wait until the H-4 is approved? Wait until the H-1B is approved. Don't
maintain your status until you know you don't you can't or
otherwise you'll be taking unnecessary risk.
Exactly. Yeah. From Chandra.
I'm planning to go to other country, not the country of my citizenship. Can I get stamping done there? Do you recommend to do it now or hold off on that? Again, I'm assuming you are on H-1B. You haven't mentioned that. I'm going to make that assumption.
Yep.
You can do a third country national stamping. Yep. The rules don't change.
Yep.
We're not recommending travel at the present time because of the very fluid situation that's happening right now.
Yeah.
Otherwise, there's no change.
Third country stamping is always discretionary. There's an idea in the built into the law that they expect you to go for stamping in your home country, but honestly, I never really hear of people having problems with third country stamping.
Mostly in Canada and Mexico.
Yeah. And
surrounding countries because they understand traveling across the globe is not something that they would require everybody to do.
Yeah.
All right, next one, Brian.
Yeah.
If a person in the U.S. applies for an H-1B extension next year, does a $100,000 fee apply? Again, no, it does not apply.
This fee relates to people seeking entry to the United States pursuant to an H-1B filed after the date of this order.
Yeah.
Here we are. I'm an F1 student currently in the U.S. right now on STEM OPT. Does a $100K fee affect me if I got picked in the 2026 lottery?
No, if you do a change status, I think it's going to be fiscal year 2027, but I understand what you say.
Yeah, coming lottery.
Yes, it will not affect you if you don't leave the U.S.
Yep, yep. Chandra.
I have an H-1B from employer A. I'm currently outside the U.S. for 2 years. Employer B wants to take a transfer of my H-1B. Should employer need to pay $100,000 as I'm outside the USA? We think you are in the gray area right now. If the application is not filed yet, and there's a stamping, we think you should not be paying, but it's in the gray area because of the language is not clear yet from USCIS, which will be clarified in the next week or 2, I can guarantee you.
Yeah, I agree. I mean, but also if this person, they've been in the H-1B, been in the U.S. for the last 2 years, in theory, they could have an H-1B stamp that would make them not subject to this. In theory, of course. Yeah, I'm just adding facts, though.
Okay.
I have there's a valid visa stamping in the passport till 31st December 26, and my H-1 extension applies next year. Does a $100K fee apply to me? Bottom line is, 1, it sounds like you're inside the United States. 2, you have a valid visa stamping. 3, this proclamation should not apply to you because this proclamation only applies to, it only applies for people seeking entry.
Well, I'm going to give you a variation on that one,
Yep.
Brian. So he applies for an H-1B change extension.
Yep.
He gets approved.
Yep.
He has a valid stamp. He travels and comes back with that valid stamp.
Sure.
Is the $100,000 applies.
No, he has a valid stamp. The proclamation does not apply to those who have validly issued H-1B non-immigrant visas. Yeah.
Yep. Okay.
Yeah. It becomes much more interesting when you don't have that stamp and you travel, and after this, that's the gray area for sure.
What happens to the current lottery pick fiscal year 2026 when they have to be approved and yet and got for stamping for the people not in the U.S.? So these are filed prior to September 21st.
Yep.
And the plain language of the interpretation, not the proclamation, but the interpretation from USCIS, that this proclamation only applies prospectively to petitions that have not yet been filed. So these people are good.
Yeah, thinking about this, if they didn't allow those people to get stamping, apply for stamping, they have a massive lawsuit on their hands from people who basically got nothing out of their H-1B filings, you know? Yeah. Let me see here. One we've already answered, does it apply to extensions or transfers? And the answer is, if you're inside the United States, this is a entry-based fee, and thereby the answer should be no if you're doing these from inside the United States.
So let's go ahead and be a little bit more selective on questions
Sure.
that we have not answered. Looks like they're repeating themselves, which I understand.
Yeah. Let's see here. I'm on STEM OPT. I'm selected for H-1B fiscal year 2025, which is what we're in right now. My EMP employer filed a consular process, but it's in pending status and hasn't been approved yet. I'm planning to travel to India in this October. What is your suggestion on this? Well, this petition has already been filed prior to the effective date of this proclamation, meaning as we read it today, this is an entry-based fee for cases that are filed after the effective date. This person seems like they should be able to go for stamping based upon this H-1B.
Yes.
Yeah.
I have an H-1B valid up to May 2nd, 2026 and working in USA. My employer will file an extension in mid-November. Is the fee applicable? No, it does not apply.
Yeah. Your fear, it's not an entry, you're here in the United States. Yeah. I think that one is already covered. It seems a little bit different.
I have an H-1B renewal coming up. This is my third extension, and I got an I-140 approval. My company is planning to file a renewal in October. My current H-1B expires on January 3rd, 2026. I work for a non-profit.
And let me see if there's any, I don't see any sort of follow-up. So I guess the question must be, does this fee apply to me?
Yeah.
The answer is
no, it does not apply.
Yeah, you're here in the United States. Travel, any questions relating to travel after this is really up in the air. That's the gray areas.
Yeah.
Yeah. Speaking of, is it advisable to travel to India this December? I have a valid stamping on my passport.
Check in December. Things can be a lot calmer by then, I anticipate. If you ask me today, I would say no. You ask me in December, I might give you a different answer.
High level one is, yes, travel is scary right now because this weekend shows how quickly things can change. However, the policy from Customs and Border Protection, the people who admit you, say...
Don't worry.
Yeah.
Travel, it says.
Yeah.
If you have a valid stamp or if you have filed prior to September 21st, we have no problem with you traveling and coming back. That's the memorandum issued by USCIS on September 20th, over the weekend.
Yeah.
Yeah.
Let me see.
I'm not sure that memo has been read by everybody at the border. That's the problem.
Yeah, that's a great point. I'd expect more confusion out of this for sure.
Yeah. I got a job. If job got terminated on H-1B and one switched to B1 and moved back to H-1B, does the employer need to pay $100,000? If you stay in the United States throughout this entire process, the answer is no.
I agree. Let me see here. I'm on F1 visa. If I'm selected in the H-1B lottery in March of 2026 and my petition is approved with change of status, if I then travel abroad for a monthly return with a $100,000 fee, still apply to me.
Gray area.
Gray area, yeah.
Not clear on that. We don't think it should apply because the impact, the humanitarian impact on blocking hundreds of thousands of H-1Bs from leaving and coming back, unless they pay $100,000, is probably something that nobody will accept.
It's enough to get, it's enough to cause trade negotiations to suddenly,
I mean, that will be an embarrassing thing for the U.S. to do, but because there's no really benefit.
Yeah.
But the clear interpretation is that it's in the gray area. We don't think it should apply.
Yeah. Let's see here. Person having I-140 and applies for extension after September 2025 from USA, does the 100 fee K apply? And the answer, again, is this is an entry-related fee. It does not it should not apply to people who are present in the United States applying for extensions, or as the White House puts it in their version of the memorandum, renewals. That's a pretty clear renewal scenario any way you cut it, you know?
I need to travel to India urgently. Can I file my medicals without an RFE? My date is current now, EB2. I need your help, instructions to file them. The new requirement is when you file your adjustment status, you gotta include the medicals.
Yep.
Your case will be rejected if you do not include the medicals, and there's incredibly low tolerances right now by USCIS in accepting anything out of the ordinary. So
I'm reading this scenario currently. I'm reading this as somebody with a pending I-485, and basically they're saying, my priority date's current. I'd love to see my case get approved. I'm worried about getting that RFE. Can I just send in my medicals right now to avoid that, essentially, before I leave the country? And the answer is,
you can, but
yeah, them getting it and processing it properly is a question that is up in the air.
You can definitely do that. What's going to happen after that is not something.
Conventional wisdom is USCIS is very bad at accepting documents without a filing fee attached to them or an RFE attached to them. You know, a variation on the question.
Is there a rule? Is this rule applied to H-4 visa? No.
Yeah, they've not said anything about $100,000 per person. Yeah, just per the H-1B worker. Not yet. Yeah.
I have an advanced parole.
Yep, sure.
Until 2029, can I travel on advanced parole? My H-1B stamp is expired. The answer to that is nothing in the rules that prevents you from leaving and coming back on advanced parole.
Yeah.
Whatsoever. I'm hoping that you have an EAD card that you can use so you do not have to argue anything about H-1B. And most likely your H-1B was filed prior to, if it's valid, September 21st, because nothing is approved that's filed on September 22nd. So that also will take you out of the applicability of the 100,000.
Yeah. This policy is very clearly applied to those seeking entry as somebody, a worker in a specialty occupation, H-1B, pursuant to an H-1B petition, which is not what you're doing when you're traveling on advanced parole.
Yeah.
Let me see here.
My H-1B extension was filed in May. I'm planning to upgrade to premium processing. Once my premium processing application is approved, I intend to travel to India for stamping. Is the $100,000 fee applicable to me? No.
Well, your case, yeah, you're right. This person's petition, well, first layer
filed before.
Yeah, filed before, meaning it shouldn't apply. But I intend to travel for India stamping. Would it be okay to travel to India within 2 to 3 weeks and return without any issues?
We don't recommend travel at this time. The plain language of the policy that was released says, yes, you can travel. I personally not prepared to make recommendation for travel right now based on 30 years in this business.
Yeah. Ooh, this is a good one. My application got procedural reject because missing one of the documents. Now they're waiting to receive the package back from USCIS to resubmit. Does my employer need to pay $100,000?
Well, no. I'm assuming you're in the U.S. and I'm assuming you're filing for an extension of stay, and hopefully that refiling is timely, because if you have a gap in your H-1B, non-protunct or retroactive application is not well received by USCIS.
Yeah.
But assuming all is good, you're not subject to the $100,000.
Yeah. A sort of same variation here. Currently, in the United States, planning to file an H-1B amendment plus extension. Well, you're currently in the United States. It is a fee, as far as we read it right now, it's a fee relating to entry pursuant to an H-1B, and that is not what you're doing. You are already in the United States.
Yeah.
Yeah. Let me see here.
I am with my current employer since 2018 on H-1B. Had 2 extensions. Once I get one more extension, 2027. When I go back home for stamping, does that trigger the $100,000 fee to re-enter? So once you go back on your post-September 21st extension, you enter the gray area as we read it today, and I'm sure it will be more clarified by 2027.
Yeah.
When you leave in the future, it will be a lot more clear. But today, as we sit, we're not clear on whether or not the $100,000 applies.
We already answered that question effectively. The different APs are different.
H-1B since 13 years, cap exempt, currently working for nonprofit healthcare. Can I transfer my H-1B into another nonprofit without paying the $100,000 fee? The answer, that's an excellent question.
A fun fact pattern, yeah.
Yeah, but that does not apply because you're in the U.S.
Yeah.
However, gray area when you travel.
Yeah.
Less gray probably because it is exempt. And post September 21st, I worry that this be in the. It's a still gray area, but still in a more likely than not, it may be required.
Because this person brings up the facts. They work for a healthcare facility. I'd say, we don't know how the actual entry policy is going to develop. That's the gray area. But if you're working in healthcare, I'd say you have a better argument than a lot of people about national interest being you shouldn't be subject to this fee. Yeah.
Depends on what you're doing.
This is true. Yeah. Let me see. We already answered that one. Let's see. This is a little bit different.
I had my 485 interview completed last month under EB3. Looks like now my file got transferred back to NBC. Should I be worried? Just the fact that the file transferred means nothing to me, except that I would be interested to see how did the interview go.
Yeah.
I need to know more about the interview to tell you whether you should be worried.
Yeah.
To be honest with you, I mean, we don't know enough.
That's a fair analysis, I think. Yeah. Anub, I'm on H-1B with employer A and move to employer B. Have a valid approved petition until May 2028. But need to get visa renewal when I travel to home country. Does this 100K rule apply to me? So if you have a valid approved petition to May 2028, it sounds like you probably got that in May 2025. And if this petition was filed before the 21st, it means this policy should not apply to you. However, travel right now is not recommended. Think about when you actually need to travel. That's when you got to check. Don't get your answer about your travel months or years before you actually intend to travel. Talk to somebody to get the lay of the land right before you travel. Always good advice, no matter what the climate is. Already answered this one. Check this one out.
Hi, I've been on H-1B since October 1st, 2024 with visa stamp valid until August 2027. My H-1B transfer was approved on September 11, 2025. I plan to travel on October 22nd. Does this new rule affect me? Well, it looks like it's pre-September 21st filing, and therefore, and you have a valid stamp. Both lead based on the policy released by USCIS on September 20th. It is not applicable to you. The $100,000 is not applicable to you, but travel is not recommended right now.
I'll take some kudos. Informative session. Thank you. That was our goal.
All right.
Maybe hit a few more of these things. We're coming up on an hour usually, going a little bit long here, but it's an important one.
I am on STEM OPT. If I apply for H-1B next year, should I be paying $100,000? The answer is no. If you stay in the U.S., if you leave the U.S. and re-enter, by then, after you get your H-1B, I'm sure it will be more clear. As of today, it's gray area whether or not you'll be subject to the $100,000 if you travel. But to get the H-1B, you're not subject to the $100,000.
In 2026, if I do change the status from F1 to H-1B and it gets approved, later can I go back home and get my stamping done back without the $100K fee? Again, it's gray area. It is going to be developing. Sam, think of all the things from this proclamation we didn't talk about, like recalculating the H-1B wages or the news about, the gold card and the EB-1A and EB-2. So much to talk about from this stuff. So that's a preview for what we're going to talk about on Wednesday, for sure.
Absolutely.
Here we are.
People are saying that F1 to H-1B will be exempt change of status. So you effectively cannot travel since your entry would warrant the $100,000. So let's break this up to two parts. We agree that the F1 to H-1B, our interpretation is that there is no $100,000 fee.
If you're staying in the U.S.,
If you're staying in the U.S., traveling, would that trigger the $100,000? It's a gray area today. I'm sure it will be clarified. Again, we say it's a gray area, but we also say it's not likely it will be applied, but that's based on our projection. But nothing written in the law today that clarifies whether it is applicable or not when you travel.
Let me see here.
Anything on immigration questions?
Oh, we got tons of immigration questions. That U.S. ones. This one is the one from.
Anything that we have not visited?
Let's see here. Not really. I think let me see what we got. This one is, I've approved visa stamping but never traveled to the U.S. Ooh. I have an approved visa stamping and never traveled to the U.S. Is this proclamation applicable for my case? I don't think we've encountered that exact factual scenario yet.
So approved H-1B stamping, meaning that it has an approved H-1B prior to September 21st.
Yeah.
And based on that, the proclamation is not applicable to you, and you should be able to travel without paying the $100,000 fee or the employer paying the $100,000 fee.
I'm going to check to see if there's any.
Well, let me ask you a question.
Sure.
Is it clear that the employer must pay the fee, or can the employee pay the fee?
If the employer can pay, if the employee can pay that fee, I want to come work for them instead of working for the employer.
But it's clearly the employer has to pay for it.
Yeah, it's H-1B classic rules that the fees, even these new and exciting ones,
It's
got to be paid.
illegal for the employee to pay for it.
Yeah.
It sounds about right. Yeah.
Yeah, these are ones not really related to the. I think we've probably covered everything here.
So if you had immigration questions.us that's not related to today's topic, we're going to take it Wednesday and bring them to you here as a priority because you've taken the time to put it there. So bring them on and we will answer your questions. Wednesday, 6 o'clock for half an hour at least. Thank you guys for listening to us, and there could be changes on this program by then. Who knows? And